I declare the motion passed.
根據釋義
Proposed resolution under the Interpretation and General Clauses Ordinance to amend the Dutiable Commodities Liquor Amendment Regulation 2015. Members who wish to speak on the motion will please press the Request to Speak button. I now call upon Mr. Sin Chung-kai to speak and move the motion. Mr. Sin Chung-kai. President, I move that the motion, as printed on the agenda, be passed. President, the administration has proposed to amend the Dutiable Commodities Liquor Regulations 23 so that the validity period for the liquor license will be extended to 2 years. And the amendment that I'm going to move is that on top of that, there should be public safeguards. And there are 2 points here. First, under A, during the 2-year period immediately before the liquor license renewal application, there has not been any adverse track record that has been confirmed or any enforcement action taken against the licensee, nor that any complaint or objection has been received by the board, by any members of the public, before a decision is taken to extend the validity period of the license to 2 years, or that the board will also have to be satisfied that the licensed premises have not caused unreasonable nuisance to the persons residing in the vicinity. Mr. President, the normal license period has been extended from 1 year to 2 years in order to give the board more flexibility in dealing with cases with more justifiable grounds, so that the license can be extended to 2 years, so that in scrutinizing cases that are less complicated, then that would be dealt with more expeditiously, so that the board can concentrate on the more complicated cases where there are objections and so on. And there is a definition under the bill, and what I'm trying to do is to include that in the regulation, so that that would become the Part A of my amendment. Well, that is originated in 2011 when the administration reviewed the liquor licensing system, and the stakeholders, including the sector, the members of the public, and also the district councils, have also given their views. And in concluding such a review, the administration submitted a report to this council, and it said that generally speaking, the industry supported any initiatives that would facilitate the operation, but then it did not support any stepping up of regulation, including the upper stairs pubs and bars. On top of that, in areas where there are more pubs and bars, the local representatives as well as residents urged the administration to regulate such premises more stringently, and there should be more focus on the premises that have caused nuisance to the vicinity. And therefore, for the business facilitation measures, they do not have strong views about that, but then some members of the public are against the idea of extending the licensing period to 2 years. And also in the summary of the report, it says that district councillors have also been raising this, and some traders have also said that in order to ensure that the licensed premises would be able to comply with the licensing requirements, then for premises that are selling liquor without a license, they should be subject to more hefty penalty. And it's proposed that there should be a demerit point system against these premises. And also, in considering any application, the board apparently would be more supportive to the trade rather than the residents in the neighborhood. And the additional conditions that have been attached would just facilitate the operation of the premises without including any clauses to protect the public. And it's been said that during the interim review on the 2-year license, and in the process, the board would also be consulted, and it's proposed that the executive body, upon the coming into effect of this arrangement, well, since this is an administrative arrangement without any legal effect, for premises that have already got their license renewed for 2 years, and if it's to be renewed for another 2 years, then it's suggested that when certain licensed premises have already got records where enforcement action has been taken against them or confirmed or complaint cases against them, then the board should seriously consider whether or not another 2-year license should be issued or renewed to the premises. And therefore, after serious consideration, even if there is some enforcement action or confirmed complaints, in some cases the premises will still get a renewal of license for 2 years. So the Democratic Party has looked into this, and if the licensing period is to be extended from 1 year to 2 years, then we do not have strong views against it. But then if there are premises that are involved in enforcement actions or confirmed or verified or substantiated complaints, then we would beg to differ from the proposal. According to records in 2014, where there were some 2,356 cases of complaint, and for substantiated cases, there were 1,138 cases, and for the premises involved, there were 511 cases. In other words, so out of the 1,138 substantiated cases, it involved more than 500 premises. It means that many premises have been repeatedly complained against. So, President and colleagues, if you look at the amendment that I am proposing this time, it just affects some 6,800 licensed premises, so it's only about 7.5% of the total number. In other words, those who have had substantiated complaints against them. So if they have had substantiated cases of complaint, either they have been subject to verbal or written warning, then they would not have their license renewed for 2 years. So there are two amendments. The purpose is to ensure that either the administration or the future enforcement agency would have enough time to step up their processing of such problematic cases in the future, instead of just renewing their license 2 years every time. And then in dealing with cases involving substantiated complaints against licensed premises, the board will have to be satisfied. So before the renewal is granted, it will have to be satisfied that the licensed premises have not caused unreasonable nuisance to the persons residing in the vicinity. I believe that my amendment has struck the right balance. That would not affect the purpose of your amendment, while enabling the relevant authorities to focus their attention on premises which have attracted more complaints. Mr. President, looking at the proposals made by the administration on the liquor licensing system, we find it disappointing, because in the past some members have suggested ways of enhancing the regulatory regime so that the board would have a chance to listen to the objectors' comments. But then on this occasion, the administration has totally ignored that part. And I find it somewhat regrettable, because the administration has only heard the voices from the trade without listening to the views of the residents. In fact, in many districts, including the Central and Western District, Prince Edward, Yau Chim Mong, and Kowloon City, in these districts, there are many licensed premises which are very close to residential developments. And under the present system, which has not been working, all residents' complaints would be dealt with by the police, which are not supposed to be the enforcement agency on the liquor licensing system. And the police would not be able to deal with the noise complaints against the interior of the premises. With regard to the noise nuisance caused at the street, they would just be giving advice but not taking enforcement action. And every time, given the dysfunctioning of the complaint system, every time when the licensee applies for a renewal, that's a very important avenue for the residents to voice their complaints. And therefore, to extend the validity period from 1 year to 2 years, that would also prevent the residents from attending such hearings, and that would also not be able to enhance the vigilance of the authorities against such problems. And if you do not target the premises, if you are not able to state the enforcement records against the premises, and if you think that they have already passed the interim review, then we believe that the threshold is set at a very low level. And that would also not be able to step up monitoring of the performance of these licensees. So for the 6,800 plus licensed premises, so over 90% of them have not attracted any substantiated complaints in the past 2 years. I'm referring to substantiated cases. And for substantiated cases, that would only account for less than half of the total number of complaints. So given the circumstances, I believe that my amendment has already struck the right balance between the residents' interests and the interests of the trade. I am concerned that without passing my amendments, and if the new regulation comes into effect, then the Liquor Licensing Board would almost automatically change the validity period from 1 year to 2 years for raw licensed premises, and the residents will have no avenue to voice their complaints. In fact, they have been subjected to different forms of nuisance, including, well, outside the bars, there would be people shouting, yelling, and there are also hygiene problems relating to customers throwing up. And nearby the premises, there would also be nuisance behaviors or even fightings. But then upon receiving reports, very often when the police officers arrive, it's already too late, and even after the complaint has been lodged, no action would be taken, and therefore the deterrent effect would be very limited. So we have proposed 4 amendments this time, and out of them, 2 were deemed to be out of the scope of this amendment by the President. And if you look at the 2 amendments, in fact, it's been ruled out of order by the President, so Ms. Helena Wong will be elaborating on that later. But then if you look at the 2 amendments, in fact, the purpose is to make sure that the board would be listening to the complaints by the residents. Number 1, they would have to make reference to the appeal mechanism. In other words, if no less than 20 residents living within the 400 radius of the premises have lodged complaints with their names included, then the board will have to investigate. And we also require the liquor licensing application and also the related consultation matters being spelled out specifically in the law. For example, you will have to put up notices in the neighborhood. So for the details, Ms. Helena Wong will be explaining in detail. As to the grounds for not accepting these 2 amendments, well, the President has ruled that those amendments were out of the scope of the proposed amendment on this occasion. Mr. President, I would also like to call upon all members of this Council. Well, if you look at the amendments that are moving, they are trying to echo to the needs of the residents in the neighborhood. In fact, they strike the balance between the interests of the sector and the residents. And the impact on the industry would be minimal because, well, in any case, they will be getting a 1-year license. So even if they fall under the category of premises attracting substantiated complaints, they will still be able to get a 1-year license. But then for premises that have attracted substantiated complaints, they would not be getting a 2-year license. Instead, they would only get a 1-year license. So this amendment is already very mild because we have not increase the burden of those who have been the subject of complaints. It's just that their cases will have to be reviewed once every year. But then for those that have not been subjected to any complaints, we believe that those cases can be processed more expeditiously and their license can be extended from 1 year to 2 years. I hope that members from other political parties would seriously look at these amendments, because we intend to safeguard many districts, in particular the Central and Western, Yau Chin Mong and Prince Edward. In these districts, there are many licensed premises, but then they are also very close to residential developments. And these residents have also been to the ward offices of district councillors to lodge complaints. I hope that you will support my amendments.
I
now propose the question to you, and that is that the motion moved by Honourable Sin Chung-kai be passed. Secretary for Food and Health. Mr. Deputy, the main point of Mr. Sin's resolution is to stipulate in the regulation that if there are certain factors, then the LLB cannot approve licenses with a validity period of over a year. First of all, I must emphasize that we subscribe to the importance of protecting residents in the vicinity who should not be affected by unreasonable nuisance. In fact, in order that there would be more room to listen to views of the community, the LLB has already taken its initiative to amend the procedures for the transfer or renewal of licenses. Starting from May 2013, any such applications are the subject of, first, that there was objection at the last renewal, or two, that was a complaint record in the last 12 months. Then, when the LLB processes such applications, it will first of all have to consult the district councillors of that district. And also, in December 2013, the LLB released guidelines on assessing liquor license applications, listing the factors to be considered so as to enhance transparency. Because of the actual environment at upstairs bars, it is comparatively difficult to do enforcement and inspection work vis-a-vis fire safety, noise, environment hygiene, and public nuisance. They cause more worries to the public and attract more complaints from the community. Therefore, the guidelines already say that upstairs bars must pass through a particular examination procedure, and also it can allow the LLB to stipulate the maximum capacity that can be accommodated, and also there will be more stringent licensing conditions with regard to noise abatement. According to the resolution moved by Mr. Sin Chung-kai, if certain factors exist, the LLB should not approve LLB or liquor license that have a validity period of over a year. I believe Mr. Sin has taken reference from the proposals we have made in the Legislative Council brief. And we have actually consulted the LLB on similar views proposed by Mr. Sin, and the LLB is now discussing the factors to be considered when a 2-year license is to be issued, including updating the guidelines that I mentioned. Basically, we have no objection to stating what requirements or considerations there will be in approving a 2-year license, and we have made such proposals. According to Regulation 17 of Dutiable Commodities Liquor Regulations 109B, LLB must not grant a liquor license unless it is satisfied that 1. The applicant is a fit and proper person to hold the license, 2. The premises to which the application relates are suitable for selling or supplying intoxicating liquor, and 3. The grant of the license is not contrary to the public interest. We understand that Mr. Sin would like such requirements to be written into the law. We are of the view that this will have more disadvantages than advantages. First of all, if all these requirements of the LLB are written into the law, this will derogate from the flexibility that the LLB can have in considering other factors and also the weighting to be given to the different factors. After the regulation is in place, if the LLB should find that there are other factors that warrant more consideration, including developments that are unknown to us at this stage, then they will have to amend the regulation in order to implement those. Or else the LLB will have to issue or approve a 2-year license according to the law, and this may not be advantageous to the residents nearby. And also, Mr. Sin has detailed his resolution. However, it seems the wording is such that will give people the impression that even new licenses can be given a validity period of 2 years. This is not the wish of the government. This shouldn't be Mr. Sin's wish either. But then the wording used might just lead to that result. The government hopes that new licenses should only be for 1 year, and it is only when there is a good track record in at least 2 years preceding or immediately preceding the renewal, then there will be the possibility of a 2-year renewal being given. And also, other parts of the resolution are not clear. For example, Mr. Sin is saying that the licensed premises, if they caused unreasonable nuisance to persons residing in the vicinity, then there should not be a license of more than 1 year issued. But how do you define persons residing in the vicinity and unreasonable nuisance? Such can be easily challenged in the courts. And other wording, say, for example, substantiated complaints. Such administrative wording may render the regulation difficult to enforce. Mr. President, I will reiterate our stance. We agree that persons residing in the vicinity should not be unreasonably caused nuisances. At the relevant subcommittee to study the amendment regulation, the government has already promised that there will be discussion with the LLB, and the LLB is now processing the considerations for issuing 2-year licenses upon renewal so that they can be included in the guidelines for enhancing transparency. Based on the above reasons, I hope members will object to the resolution. Thank you.
Mr. Tommy Zhang. Mr. Deputy, as chairman of the subcommittee on the 2 regulations, I would like to report to members the work of the subcommittee concerning the proposal to extend the maximum validity period of a liquor license from 1 to 2 years. The trade welcomes the proposal as a trade facilitation measure, but then of course some members are concerned that the LLB may err on the lenient side in vetting liquor license applications. And some are worried that although there may be objections or complaints from those living in the vicinity, the LLB may still decide to issue licenses with a validity period of 2 years. And then concerning the but then some are of the view that the LLB and the Secretariat should concentrate their efforts on new applications and also contested applications. If the validity period for the good track record premises are for 2 years, it is said that there will be 3 conditions that the LLB will comply with in deciding to issue 2-year validity licenses, including not having received objection or adverse comments from the public for the license renewal application, and having been the premises having been granted a full-term license at the time when the licenses were last approved or renewed, or not having substantiated complaint or enforcement actions recorded against the licensed premises or the licensees in the licenses register for at least 2 consecutive years immediately before license renewal. Mr. Sin Chung-kai has indicated that he will move a resolution to the effect that there should be sound assessment criteria for deciding which cases are cases with good track records. And the member is concerned about nuisances caused by licensed premises to the residents. According to the administration, if there are major problems, then liquor licenses can be suspended or even cancelled at any time, even if they are valid for a 2-year period. And concerning those who are aggrieved by the LLB's decision, they can appeal to the MSAB. They can also seek a judicial review. And then there is this administrative measure whereby for problematic cases, the DC member in the relevant constituency is consulted as a matter of course. For non-controversial cases, the procedures are simpler than the procedures for dealing with new applications and contested renewal applications. And so the cost for the renewal of a good track record case should not be double that of the existing fee level, even if it is to be valid for 2 years. Now, President, I want to say that, in fact, every time a liquor license has to be renewed, an advertisement has to be placed in the newspapers. There are a lot of other requirements, and the compliance costs are high. This time around, the government intends to extend the maximum validity period of a liquor license to 2 years. For the good track record cases. And so we are really already overjoyed, and we hope that members will not oppose this proposal. Some are worried that if a license is valid for 2 years, residents will not be able to make complaints, and there is nothing they can do about the licensed premises. But in fact, residents can always make reports to the police. If there is a noise nuisance, they can approach the EPD, and such complaint records will be brought to the attention of the LLB. So residents can complain anytime. I think what's important is whether these complaints are substantiated, and then of course this is for the law enforcement agencies to investigate. I served on the LLB for 8 years. I was fair and just, and in fact, if licensed premises caused a lot of nuisance, then I would suggest that a renewal be not granted. But my experience tells me that many complaints come from district councillors, and then these district councillors print standard letters for members of the public or the residents to sign, and then some district councillors raise objections, and then they attend LLB hearings. But some raise objections but do not turn up at LLB hearings, and some district councillors seem to feel that all licensees are sinners. They cause nuisance to the residents. They cause environmental hygiene problems. They make the streets untidy and dirty. And some say that, in fact, customers are drunk, and then they may commit offenses like indecent assault. Now, in fact, if you ask members of the public, they will not want liquor licensed premises near their homes. They want to have swimming pools, parks near their homes. And so concerning the requirement for the LLB to arrange a public hearing upon receiving a complaint made by 20 or more persons residing within a radius of 400 meters from the premises concerned, is that really, that's going to be a disaster for the industry. Now, in fact, the LLB enjoys a lot of powers. If there are irregularities found, the LLB may suspend the license or even cancel the license, and conditions may be imposed on the licensee, for example, capping the maximum number of people on the premises, requiring that the doors and windows be closed after a certain hour, and so on and so forth. And then a midterm review mechanism has been proposed. In other words, in the 11th month, during the validity period of a 2-year liquor license, the Secretariat or the FEHD will check the record of complaint and enforcement against the premises and report to the LLB. And liquor license premises with no record of enforcement action or substantiated complaint will be deemed to have passed the midterm review, and they can carry on with their operation within the remainder of the license period. And if in the midterm review irregularities are discovered, of course, the LLB will take resolute action. And only the good track record cases will be extended for 2 years. Now, if there is, there are complaints, if the complaints are substantiated, then the cases will not be regarded as good track record cases. And substantiated cases mean records of verbal warnings or written warnings. And the LLB guidelines will be updated. The factors to be taken into account by the LLB will be known to the public, so everything will be very transparent. Mr. Sin Chung-kai's amendment seeks to include all the criteria for assessment in the legislation. This is not necessary. And also Mr. Sin Chung-kai has proposed conditions that are harsher than those proposed by the administration. So I will not support the amendment. Mr. Sin Chung-kai proposes that in fact, the scope of substantiated complaints will be expanded, including non-liquor license related cases or complaints. For example, if the water meter has broken down and then there is a complaint, then is it that there can no longer be an extension of 2 years? And the second condition is that the licensed premises have not caused unreasonable nuisance to the persons residing in the vicinity. So what is meant by unreasonable nuisance and what is meant by residing in the vicinity? And the definitions are not clear. District councillors may seek a judicial review lightly. According to the government, 78% of the cases are regarded as good track record cases. There are 6,800 licensed premises, and about 20 or less than 20% of them have bar endorsements. So we believe good track record cases are mainly restaurants and not bars. So I think Mr. Sin's amendment will only victimize restaurants and will not be able to really help make sure that bars will cause less nuisance to the residents. Now, I want to talk about other aspects of the amendment. And then concerning the proposed fees for a new 2-year license, which should be 1.5 times the fees for or the existing fees. I understand that under the weighted average calculation approach, the cost recovery rate will be lowered to 119% from the present 149%. So in other words, the fees exceed the costs. So the industry should have opposed the proposal, but then the industry has decided not to raise an objection because they think it's acceptable. But please always bear in mind the impact of fee increases on operating costs. And then another proposal is that digital signatures be accepted, or passwords assigned or approved by the LLB can be accepted in an application submitted in the form of electronic records. In fact, I have always advocated the, allowing the trade to submit applications by electronic means, but not all or not many applicants do have digital signatures, and so I support this present proposal by the government. I want to also urge the government to streamline license application procedures, and there should also be an arrangement for a substitute or alternative licensee in case the licensee has to be absent for a period of time. Thank you.
Mr. Kwok Wai Tong, in recent years, there are more and more bars and pubs in operation. That has not just caused nuisance to the nearby residents, it has also given rise to concerns about fire risks. And there are also traders asking for the licensing regime to be streamlined. That's why upon the review of the licensing system, there was consultation, and the Environmental, Food and Hygiene panel of this council also repeatedly discussed this issue of liquor license. And during the past 2 years, a number of administrative measures have been put in place by the administration in order to improve the licensing system. For example, upon the application for renewal, a number of conditions would be attached, and if there is any objection or complaints against the premises, then in the course of scrutinizing the application, local district councillors would also be consulted. And in December 2013, the administration also issued guidelines for application for liquor license, and certain factors would be taken into account by the board, and that's for the reference by the applicants as well as the public. And on this occasion, the amendment is to extend the validity period from 1 year to a maximum of 2 years, and the justifications, as seen from the paper, out of the 6,800 premises under application, many of them are also covered by a restaurant license, and for those with a bar endorsement, the ratio is relatively low. So it shows that mainly the amendment is proposed to help the complying premises in order to streamline the application procedures. And that would also reduce the work pressure on the liquor licensing board, so that it can focus on the more controversial cases, or cases which have been objected against. And that would also reduce the workload of the Secretariat. So from this perspective, we believe that the proposed amendment by the administration is desirable. But then at the same time, we also have to understand that extending the validity period of liquor license from 1 year to 2 years will mean that for residents who are subject to the nuisance, their nightmare would be extended for another year. In other words, they have been made to swallow this for another year. And on the face of it, you're giving the liquor licensing board more flexibility in dealing with such applications. And in putting forth this application or this proposal, the premise is that there must be a good track record before such an extension would be approved. And also, in the 11th month of the licensing period, an interim review will be conducted. We believe that the administration's amendment has already struck a balance between the controversy, and the administration has also set out that by having a good track record, it means that there has been continuously good performance, meaning that there has not been any law enforcement action taken against the premises, nor has it attracted any complaints. And in considering such renewal application, a full year's license would also be issued. And thirdly, when a notice is put up for the renewal application, no adverse comment or objection has been received. So if the premises are able to meet the above-mentioned conditions, then that would give rise to less controversy, and it would also be subject to less complaint from the public. So we believe that that's acceptable. And the administration said that, the premise for having a good track record is very similar to the proposed amendments by Mr. Sin Chung-kai. But then we believe that when the Liquor Licensing Board deals with such applications, there should be more flexibility. But then if the requirements are to be put into the law, then it would be too rigid, and the work of the board would not have any flexibility. Other than those residents who have been subjected to serious nuisance, there can also be frivolous complaints. For example, there might have been competition from the nearby pubs, and therefore the authorities might not be able to really know the situation. For example, some drunken customers might cause nuisance in the streets, and as a result, there might be complaints. And if that is the case, then if that affects the application for renewal of license, that would also not be fair to the applicants. We believe that the conditions could be included in the guidelines for application for liquor license instead of including it in the law directly, so that the board in dealing with such cases will have greater flexibility, and it would also be closer to the real situation on the ground. That's why we would oppose the amendments moved by Mr. Sin Chung-kai. Mr. Deputy, I'd like to reiterate that for residents affected by the premises, we do not think that they should be subject to further nuisance because of the change in the system. But then for the affected residents, if they give any comments, the administration must respond specifically to their comments, instead of just looking at it from the perspective of facilitating the operation of business. That's why during the interim review in the 11th month of the license, it should be a genuine review instead of just giving advice, and then the license will be renewed. And also for upstairs pubs and bars, there are so many there. But then upon the review of the system, there has not been any recommendation by the administration to regulate the situation. And if it's just proposing some facilitation measures, then the administration must look at the problem of upstairs bars, and there should be more regulation in order to reduce the nuisance caused to the residents and also the risk involved. Thank you.
Mr. Wong Kwok-hing. Thank you, Mr. Deputy. I rise to support the government's resolution, and I object to Mr. Sin's amendment. Mr. Deputy, I was a member of the then Urban Council. After it was abolished, I was appointed a member of the Liquor Licensing Board for 6 years. Therefore, I have taken part in the work of monitoring the issue of liquor licenses for a long time. I also understand the trade very well, and I certainly know the feelings and comments from residents. The government is proposing an improvement measure, and I think it's worth our support for the following reasons. Number one, uncontested cases with a good record will be renewed for 2 years. It is an incentive measure, and it has a certain effect. This will encourage licensees to practice self-discipline and abide by the law. If they do so, if they strictly discharge their duties as licensees and manage the premises well. If residents in the vicinity do not complain, and if customers also keep to law and order, and if the business is run well, then they will not cause unnecessary trouble to the enforcement agents. This is a carrot to encourage licensees to exercise self-discipline and abide by the law. After 1 year, if they have a good track record, they will be able to get the license renewed for a longer period than 1 year. They do not have to seek renewals every year. This is the carrot. I think it's an appropriate policy. Plus, we can take a look at operators or applicants who have a good track record. Very often they are restaurants. They are catering establishments mainly serving Chinese food. They are usually uncontroversial. There are many people working in this trade. There are many job opportunities in this trade. And usually, they do not attract complaints. Therefore, here I'm not talking about bars, but restaurants. You should facilitate their operation. I think it's a good measure. And then also, this proposal by government can help to save resources. And the resources so saved will mean that the enforcement departments can concentrate on high-risk premises attracting more complaints. So, enforcement agencies can follow up on complaints lodged by residents. As you know, the enforcement agency here is the police. Only the police have the enforcement powers to inspect premises and ask for licenses to be checked. And of course, the EPD, the LBHD are relevant departments. However, it is for the police to enforce the law. If we adopt this improvement measure, then enforcement departments will be able to make the best use of police power and concentrate their resources to protect the interests of people living in the vicinity of the premises in question. Number 4. Our biggest concern about the government's improvement measure is whether it will decrease transparency and also lessen the power of residents to lodge a complaint and object. Well, this will not happen, and I emphasize this will not happen. For applicants, as long as he has managed his premises not in a good way, and if there are other crime cases, then members of the public can always complain. They always have the power to, and applicants have to take out advertisements on newspapers to facilitate objection, if any, from residents. Therefore, the public will still have access to the information. They will still be able to complain, and the LLB and the police will have to record such complaints and investigate. They cannot just dump these aside and not do anything. So, most importantly, we have to consider whether the improvement measure proposed by the administration will deprive residents of their right to know, their right to monitor the premises, and also the right to object. And the answer is in the negative. Based on such analysis, I'm of the view that the improvement measure proposed by the administration is worth our support. Mr. Deputy, I'm of the view that if the administration can focus their attention on the keeping of records on complaints, they can further improve the situation. And I'd like to talk about the so-called Soho district in Central. It seems the Soho district is expanding its boundary. It's like eating into the nearby area, and residents are affected. So the administration really should look at applications that may cause nuisance to the public, and you should spend more energy and police power on this area. Number two, the Soho area is expanding westwards towards Shangwan and the Western. There is nuisance caused because many people live there. And there is no question of a 2-year license. The administration should step up enforcement and inspection in this area. Number three, like what Mr. Kwok Wai Keung said, upstairs bars. In multi-story commercial buildings, there are more upstairs bars opened. We are concerned about the risks imposed. In the case of an accident or a fire, there will be an immediate evacuation problem. These bars are high risk. I hope the administration will do more to tackle these bars. Number four, the media report, and also there are complaints about illegal selling of liquor at beaches, at barbecue sites. These people don't have a liquor license, but they sell liquor illegally. It is a nuisance. It is a crime. I am of the view that the administration should pay more attention to these cases and do more follow-up. And I hope the LRB will understand that to residents, these may pose problems of environment, fire escape routes, and noise and other environment hygiene problems. I hope there will be more attention paid to these. I think that is more practical. So based on such analysis, I think we should be pragmatic and support the administration where it has a good reason to do so. So I speak to support the administration's proposal and object to the resolution by Mr. Sin Chung-kai.
Oh, you.
Dr. Kenneth Chen. Thank you, Mr. Deputy. I think different political parties broadly agree that for good track record premises, the validity period of the license should be lengthened from 1 to 2 years, and then the fees will be 1.5 times the present level of fees. This is because the cost of handling a good track record case is not really very big. But the Liberal Party through Mr. Tommy Chung, held a slight or announced a slightly different position. Now, Mr. Sin's amendment seeks to include in the legislation the criteria or the definitions of good track record. So Mr. Sin Chung-kai simply wants to include the criteria in the legislation, and the Secretary's response was that there would be more disadvantages than advantages in laying down the criteria in the legislation. He didn't say that the proposal was entirely wrong or very wrong. He merely said that the LLB as the licensing board should be given more discretion, and but then Mr. Tommy Chung is saying that the industry is suffering, it is operating under great hardship, and district councillors they always complain. So I think perhaps he is trying to suggest that if functional constituency members will try to protect the interests of the industries concerned, elected members will not consider the interests of the industries, and all those who do business are considered by directly elected members as villains, as causing harm to members of the public, and so they should be driven out of the community. In Hong Kong, many liquor license premises are located near to residential developments, and there are these upstairs bars which are in commercial residential buildings, and of course those living near the liquor license premises, especially those living near upstairs bars, may query whether the LLB has done its job, because these residents may want to have a discussion with the LLB as to how things can be improved. So it is not that the public simply want to drive away all the bars or restaurants. So the government is telling us that in fact there are these good track record cases, and many of them are restaurants, most of them are restaurants, and so the validity period of their licenses should be increased to 2 years, and then the fees should be 1.5 times the present level of fees. So on this matter, the Civic Party supports the government, but then I think the government knows what the difficulty is, and that is the criteria to go by. So, in fact, the criteria in Mr. Sin's amendment, in fact, have been provided by the government. I think as almost a word-for-word version for the government's version. And concerning good track records, is it that the LLB will dig up this paper and look at the footnote, because the definition or the criteria for good track record are in the footnotes. So is there anything, or will it do any harm if we include this definition or these criteria in the legislation. We in Hong Kong observe the rule of law, and the LLB exercises its statutory powers. So is it not that including all these in the legislation will give rise to more advantages than disadvantages? But the Secretary said that the LLB will get less discretion, and as a result, members are concerned. We are supposed to be the gatekeepers. We do not know whether the criteria written in the footnotes will be adopted. And we do not want to be misled, and we do not want to mislead the public. The public may feel very angry. They may think that the government is cheating them again. They think that people at the highest level in the government have been cheating them, and they are cheated once again. So Mr. Sin's amendment can facilitate the license issuing procedure. Which liquor license premises can get 2-year licenses? What is meant by a good track record? According to Mr. Tommy Cheung, the liquor licensing or the license issuing process is extremely arduous, and it's really a very difficult journey. But then, according to the figures given to us by the government, in 2014 there were 428 shops with complaints substantiated, but some of them still got their licenses. But of course, some of them got only less than full-term licenses, and some have to comply with extra conditions. So in 2014, there were 428 shops with substantiated complaints, which sought renewal of licenses, and only 8 such applications were rejected. Mr. Tommy Cheung seems to have said that in fact it's very, very difficult to have the license renewed, and the residents simply want to wipe out all liquor licensed premises. So I think the LLB, the LegCo, district councillors and members of the public discharge their respective duties. But then if things are clearly written down in the law, then there will be greater transparency, and that will also facilitate compliance. And so we support the government's proposal, and we think that Mr. Sin Chung-kai's amendment can complement the government's proposal. It's important that there are clear rules. So I think the government's proposal and Mr. Sin Chung-kai's proposal are not mutually exclusive. Why is it that we have to choose between the government's proposal and Mr. Sin's proposal? Is it that if we can only 100% embrace the government's proposal to the exclusion of Mr. Sin's proposal? I think we should stand in the shoes of the residents, and I really don't understand why the government thinks that Mr. Sin's amendment will bring more disadvantages than advantages. On the contrary, I think there will be more advantages than disadvantages. And then I understand for restaurants, the license is valid for a year. And so it's strange that the restaurant license has to be renewed every year, but then a liquor license will be valid for 2 years. So the operator may hold a 2-year liquor license, but only a 1-year restaurant license. And what if the restaurant license can be renewed, and yet the operator still possesses a 2-year liquor license? You may say that the restaurant operator should not apply for a 2-year liquor license. But then concerning this embarrassing scenario, perhaps the government can take a look at it. Thank you.
Mr. Ip Kwok Kim, Mr. Deputy, on behalf of the DAB, I speak against the amendments moved by Mr. Sin Chung-kai. In the amendment regulation, the validity period of liquor license can be extended from a maximum of 1 year to 2 years, and the purpose of this is to reduce the need for the board to deal with uncontested cases, so that it can focus its attention on contested or controversial cases. For operators with a good track record, that would also ease the burden by reducing the administrative procedures involved, as well as the need to put up advertisements in the newspapers about their application for license renewal. So there is no problem with this policy objective. But then in coming up with the specific provisions, we also have to consider very carefully the local residents' interests as well as their safety. In particular, their concerns that such licensed premises might be causing nuisance to them. So according to the thinking of the administration, the longest validity period of liquor license would be increased to 2 years, and only in cases in which there has been a continuously good performance or track record for at least 2 consecutive years immediately before the liquor license renewal application is submitted, will that be considered. And by having a good track record, what does that mean? It means that for at least 2 consecutive years immediately before the renewal application, there has been no record of the premises nor the licensee with substantiated complaints, nor has there been any law enforcement action taken against the premises. And also on the last occasion, upon the grant of license to the premises, it has been issued with a full-term license, and thirdly, no objection or adverse comment has been received from the public from its license renewal application advertisement. So there would also be a mechanism for an interim review, which would allow the license to be either revoked or suspended, or the next time when the application for renewal is submitted, a shorter term license would be issued. All in all, I believe that these measures have already struck the balance between taking care of the concerns of the local residents and the interests of the operators. And for the members who have spoken, including Dr. Kenneth Chan, they all find the approach acceptable. But then from the perspective of the DAB, we believe that on top of that, we believe that there are 2 points that should be considered by the administration. Number one, for the renewal conditions for premises with a good track record, that should be included in the guidelines for application for liquor license, so that the applicants as well as the public would be made aware of that. And secondly, with regard to the interim review mechanism, there should be consultation with the district councils. So the mechanism has to be improved. So we believe that those are the 2 things that have to be done. And the DAB has also noted that in moving the amendments, Mr. Sin Chung-kai has also said that for any new application of license, the board can issue a 2-year license. And Mr. Sin has not set out in the amendment that it should be subject to any restrictions. That's why the DP's suggestion, when compared to the original regulation, is actually the same. For any initiatives that can improve the existing mechanism, the DAB has an open mind and is willing to consider. But then why is it that when it comes to Mr. Sin's amendments, we have said that we would vote against it? That's because after considering Mr. Sin's amendments very carefully and the legal implications of his amendments, we find it difficult to support. Because with the amendments, it might be counterproductive because it could actually undermine the safeguards or protection for the local residents. Why? There are 2 reasons. One is about license renewal. If you look at the amendments moved by the DP, unless the board is satisfied, number 1, that the licensed premises have had a good track record, or 2, the licensed premises have not caused unreasonable nuisance to the persons residing in the vicinity. So unless those 2 conditions are met, no license valid for more than a year would be issued. So if the premises can meet the 2 conditions, then it can get a license of more than 1 year. But then in the amendments moved by Mr. Sin, what is not mentioned is that it can be 2 years, 3 years, or even 30 years, because if you just look at the wording here, Mr. Sin only requires the board to issue a license that can be longer than a year. I don't think that's the intention of Mr. Sin, but then that's the unclear outcome of your amendments. Second, if you act in accordance with the guidelines of the board, so long as there is any objection or adverse comment made by any member of the public, then the board can reject the application. But then according to the amendments moved by Mr. Sin, if the board is satisfied that the licensed premises have not caused any unreasonable nuisance to the persons residing in the vicinity, for example, if the applicant can prove that the licensed premises, even though they have caused some nuisance to the residents nearby, the situation is not really that unreasonable, then the board might still be able to issue or grant a license for 2 years. So even if there is objection from members of the public, or if there have been adverse comments, still it's up to the board to decide. So on the face of it, the DP and Mr. Sin have moved the amendments, which might appear to be more stringent than the guidelines, but then the actual effect is that it would undermine the protection or safeguards afforded to the local residents. And a number of members have also spoken just now, and amongst them, Dr. Kenneth Chen spent 3 minutes on the populist approach of some district councillors and also the plight of the catering sector. Well, I do not really want to comment on that, but then Dr. Chen also said that in the Central and Western District and also Yau Chi Mong District, the residents are very concerned about this. I think there is a need for us to explain the issues here. Last Thursday, that is on the 19th of March, the Central and Western District Council passed a motion moved by a DAB member, and well, let me read out the wording of that motion. That this council is of the view that before the administration is able to effectively resolve the problem of nuisance caused by liquor licensed premises, it should not incorporate the recommendation that liquor licenses validity be extended from 1 year to 2 years under the Dutiable Commodities Liquor Amendment Regulation 2015. This Council urges the administration to comprehensively review the liquor licensing regime, and it should also step up the enforcement of the regime so that the mechanism can be enforced more effectively. So that's the motion, which was supported by DP members in the Central and Western District Council. Hence, Mr. Sin's amendments vis-a-vis the content of the motion passed by the Central and Western District Council are actually at loggerheads and is quite different from what has been endorsed by the District Council. That's why we would be against the amendments moved by Mr. Sin. Thank you.
Dr. Helena Wong. Mr. Deputy, bars or upstairs bars, which are the trend now, they concentrate in Central and Western and my constituency, Yao-Ching-mong in Kowloon West, and they can be found all over the place. I don't want Mr. Ip to leave the chamber because I have to answer his question, and I think that his understanding is incorrect. There is a lot of nuisance caused by such upstairs bars, and they concentrate in Central and Western, Prince Edward, Yao-Ching-mong, and Kowloon City. The present complaint system is ineffective, and I will give you examples. Residents' complaints are handled by police officers who are not specially tasked to issue liquor licenses, and according to the law, the police cannot tackle noise problems outside premises or noise in the streets outside street-level shops. They will just advise the premises. When the complaint system is ineffective, when liquor licensed premises go for a renewal of license every year, they are confronted by residents, and the residents will have that only chance to make a complaint. The administration is saying that the renewal can be for 2 years. That, in fact, removes the opportunity for residents to make a complaint directly to the Liquor Licensing Board every year, and they have to wait 2 years to lodge that complaint. So people are not so aware of the nuisance caused by bars. The administration says there could be interim review mechanisms, and if an interim review is done, if there has not been enforcement actions against the liquor licensed premises, or if there is no complaint recorded, then the relevant premises would be deemed to have passed that interim review. But the DP is of the view that that guideline or criterion is too lax, and it is not effective in regulating licenses. In most of the cases, residents may be seriously disturbed by noise and hygiene problems. When the police go there, they will just issue some advice and they will go. Very often the police have no power to enforce the law. Say, for example, patrons will gather outside the bar and they make a lot of noise, and yet the police officers cannot do anything. We expect that there will be a majority of such licensed premises which are causing nuisance to the public, which will still get a pass in the interim review, and residents will have to tolerate that nuisance for 2 years, and then they will have a chance to make a complaint only when the license is due for renewal. Therefore, the amendment regulation does not introduce any effective measures to balance the situation against the interests of the public. We think that is a big shortfall in that amendment regulation. The DP Sin Chung-kai has moved 2 amendments, and I actually wanted to make 3 amendments, but I was ruled out of order. Mr. Sin is only seeking to put restrictions on licensees which have a problem. We are not objecting to those with a good track record. But I think the regulation cannot help us balance the interests of the public against the needs of these bars. We just like to introduce the non-binding guidelines into the law so that problematic licensed premises will not be able to get a renewal automatically for 2 years. We hope the guidelines can be listed into the regulation. I'd like to respond to what Mr. Ip-Kok-Him said. I'm very disappointed with him. He's a senior or very experienced legislator from the DAB, and yet he has not read the amendment regulation carefully before he spoke. He said that he was also concerned whether Mr. Sin's amendment would allow the problematic licenses to get a renewal for 2 years and even more 3-4 years, and so the interests of the public will be further disturbed. Now please, Mr. Ip, look at the amendment moved by Mr. Sin Chung-kai. It says to repeal paragraph 4 substitute with bracket 4. Before the granting of an application for renewal of a liquor license, the board must not grant a liquor license which is valid for a period of more than 1 year unless it is satisfied. So, your understanding is totally incorrect. Mr. Sin's amendment says, unless the 2 conditions are satisfied, there should not be the granting of a license, the validity period of which will be more than a year. You said that you were worried that it would be more than 1 year, so you would object to it. I don't know whether you have got into the habit of objecting to whatever the Pan-Democrats say. What Mr. Sin is saying that those problematic licenses should not be renewed for more than a year. And what are these conditions? Mr. Sin has listed them here, that the government authority or the board does not have any substantiated complaint or enforcement action recorded against the licensed premises. We are talking about substantiated complaints. And enforcement action. What kind of enforcement action are we talking about? Maybe prosecution? Or that it does not receive objection or adverse comment from the public. What about adverse comments? The Liquor Licensing Board says these can be oral warnings, written warnings, or prosecutions. These are adverse records. Now, unless it is proved that this has not happened in the past 2 years, then a license of 2 years can be given. There is no question of renewing it for 3 years or 4 years. And also under B, Mr. Sin says the licensed premises have not caused unreasonable nuisance to the persons residing in the vicinity. These 2 are listed side by side. So I don't understand why Mr. Ip-Kok-Him misunderstood the amendment. I hope he will wake up and read the amendment again. I think we share your view. You mentioned on the 19th of March, the Central and Western District Council held a meeting because a DP District Counseling, Mr. Hui Chi-Fong, and also Ms. Cheng Lai-King and Mr. Wong Kin-Sheng, 3 members, moved a motion at that meeting regarding the Dutiable Commodities Liquor Amendment Regulation 2015, lengthening the renewal period for liquor license from 1 year to at most 2 years. And the motion says that we object to it, and we hope the administration will amend the law to resolve the nuisance caused to public by bars. But DAB members, Ms. Silka Yi, Mr. Chen Ka-yi, and also Mr. Ip-Kok-Him, and also Lo Yi-Hang and 2 others, amended the motion moved by the DP member Ho Chi-fong. However, the spirit remains the same. So Mr. Ho Chi-fong, DP, supported the DAB's amendment. And in fact, DAB member said in the District Council that before the nuisance caused by bars is resolved satisfactorily, the administration should not propose to lengthen the renewal period of a liquor license from 1 year to 2 years in the Dutiable Commodities Liquor Amendment Regulation 2015, that this council urged the administration to review the liquor license issue system right away and also step up monitoring. Therefore, DAB members, including your good self, Mr. Ip, your amendment does not actually go against the motion moved by Mr. Ho Chi-fong. Therefore, we acted in a rational manner and supported you. And then DAB members already issued posters and are posting them up in the streets to say liquor license should not be extended for 2 years instead of 1. I have downloaded this poster for your reference. This is a poster from DAB. So just now, because of misunderstanding, you say you do not support Mr. Sin Chung-kai. Now you must have a correct understanding after listening to me, and you should support Mr. Sin Chung-kai so that you can block this regulation. If Mr. Sin Chung-kai's amendment is not passed, then the administration's regulation will be passed automatically. So before the problems are resolved, the validity period would automatically be extended. So Mr. Ip, I hope you will wake up now and not misinterpret Mr. Sin's amendment to say 3 years or 4 years. Mr. President, the administration reiterates that at the issue or renewal of a liquor license, it will certainly consider the interests of the industry and the interests of the public. They hope they can strike a balance. I also sincerely hope that the administration will strike that good balance. However, that is not reality. At the subcommittee, we have asked the administration to provide figures. Figures do not lie. Are the administration aware of complaints from the public so that when licenses are up for renewal, they would do something to balance the different interests? If we look at figures for the last 3 years, substantiated complaints and also where a renewal is sought. In other words, premises have been complained against, and in 2012, 281. This is figures from the administration. Out of the 281, how many of them have been rejected when they applied for renewal? 0. No one was rejected, even if there was a substantiated complaint. In 2013, 260 premises where substantiated complaints have been recorded against them, and 5 have been rejected upon renewal of license application. 2014, 428, where there were substantiated complaints. And at the time of renewal, how many were rejected? Only 8. A pitiful 8. Mr. President, if you tell us these figures can show that the administration is striking a balance, then maybe we are blind. We can't see how this is happening. From 2014 figures, there are 428 such premises, but only 8 have not been given a renewal of license. Well, the full term now is for 1 year. 66% or 357 of them got a 1 full year's license. And those who have got a full year's license without added conditions, there are 236. 357 got a full year term at renewal, and out of these, 236 of them did not have any new conditions added. If the administration's regulation is passed, and if unfortunately Mr. Ip Kwok Him will not support Mr. Sin Chung-kai because of misunderstanding, we can imagine that the LLB will just be doing a sloppy job Even if there are substantiated complaints, renewal of liquor license will still be approved. Even if there is a bad record, they act leniently. And also, when there is a complaint against these premises, when the police did its job, there was corruption involved, the entire team of Wan Chai were interrogated and the case got to court and someone was convicted. So if you now open your doors wide to facilitate business and you allow renewal for 2 years, and yet your guidelines are not tightened up and are not enforced effectively, then sorry, the DP cannot support you. Mr. President, we must have stringent control. I originally wanted to move an amendment so that what we are already doing can be included in the law, including that within a 15-meter radius of licensed premises, there should be the posting up of a notice telling residents that there is an application for renewal. And if there are 20 residents lodging a complaint at the same time, then the LLB should hold a hearing. Unfortunately, the President did not approve such amendments. In fact, in certain districts, this is already implemented. We just want to regularize it so the interests of residents can be taken care of. Mr. President, I appeal to DAB and other members to support Mr. Sin Chung-kai's amendment.
有冇其他議員要發言？
Does any other member wish to speak? Secretary. President, I have been listening to members' comments very attentively. I think there is one thing in common among members and among what they say, and that is with regard to the proposal to extend the maximum validity period of liquor licenses to 2 years and the introduction of a midterm review mechanism for good track record cases. Which have been granted a full term or a full-term license at the time when the license was last approved or renewed. I think members do support this direction. In fact, in the light of public concerns, the LLB launched a series of measures in 2013. Renewal and transfer cases were handled rigorously, and there are revised guidelines for the reference of the public and to increase transparency. The LLB doesn't want to issue 2-year licenses to everybody. The LLB will be updating the guidelines on assessing liquor license applications. But then those who support the amendment have raised some concerns, notably concerns of nearby residents and their complaints. In fact, I've already pointed out that residents can complain anytime they like. Of course, they can lodge complaints when a license is up for renewal, but they can also complain at any other time. Only those good track record cases will be given 2-year licenses. In other words, they don't have any substantiated complaint or enforcement action recorded. So we're not proposing to issue 2-year licenses to everyone. The arrangement proposed by the government was discussed in detail by the subcommittee. The government as well as the subcommittee thoroughly looked at the feasibility of the government's proposal. Now, we understand that Mr. Sin intends to move the amendment to better protect the interests of the public. He doesn't want to see liquor license premises causing too much nuisance to nearby residents. But then his amendment will limit the flexibility that can be exercised by the LLB. And if the criteria are written into the legislation, there will be certain gray areas, unclear areas. And so I want to point out that Mr. Sin's amendment, if passed, may be counterproductive. And I think that's the most important factor I want members to consider in deciding whether to support the amendment. The government's proposal has been discussed in detail by the subcommittee. The subcommittee has studied the feasibility of the proposal in detail, and so I hope that members will oppose Mr. Sin Chung-kai's amendment. Thank you.
Mr. Sin Chung-kai, you may now reply. Thank you, Mr. President. Well, Tommy Chung is against my amendment. Well, it's not surprising because he has to defend the interests of his sector. But then apparently some members have suggested that everything can be included in the guidelines, and that's okay. The only exception is Mr. Ip Kwok Him. In fact, our party members have supported your resolution or motion at the Central and Western District Council. And according to my understanding, if the administration is not able to resolve the problem of nuisance caused by such premises, then the 1-year period should not be extended to 2 years. In fact, I've put that in my amendments, so you can see that. Well, before any renewal is granted, unless the board is satisfied that the following has been met, or else license for more than 1 year should not be granted. So the 2 points have been included. 1, for the premises before the granting of an application for renewal of a liquor license, the board must not grant a license which is valid for a period of more than a year unless it is certified that there has been no substantiated complaint or enforcement action recorded against the premises. So I've included your amendment or your views in the amendment, and now you're voting against me. So, Mr. Ip Kwok Him, in fact, what I'd like to see is we will be doing something for the benefit of the community. So we are just trying to do something for those who have been subjected to the nuisance of the licensed premises. In fact, we might be here for a couple of years, but then for residents who have been affected, they might have been there for years or decades. So there might be generations of residents who have been subjected to such nuisance, and yet there is nowhere that they can turn to for redress. So Mr. Ip, look at it again. We are trying to include the motion that has been passed by the Central and Western District Council in the amendments. As Dr. Kenneth Chen just said, we have actually copied the wording of your paper. All right, this is government papers, and these are the wording by the administration. And yes, we may have to be more careful in the legal wording. But then at the subcommittee, we have asked the administration to see if they can copy the wording into the legislation, but then you refuse to do it. That's why we have to do it ourselves. And if you can take it up yourselves, then that would have been a lot better. And yet you said that at the grant of a license, if they do not have any bad track record in the past 2 years, then that would be considered. Well, after you have said that to the subcommittee, you talk about bad track records. And then in the explanatory note, all you need to say is to explain that. So I've just copied the wording of your paper in the amendments. Please understand, in the future, the board would also have its own legal advisor, and if the legal advisor said that, well, our speeches today will not be part of the law, and therefore, well, such wording would not feature in their paper, and even your paper would not be included as part of the law. So these elements are not included in the amendment regulation. Mr. Ip Kok Him, I believe that what we have moved today is just a modest measure that we are trying to do for the benefit of the residents. So I'm saying that before the granting of an application for renewal of a liquor license, at least for 2 consecutive years, immediately before the application for renewal, the government authority or the board does not have any substantiated complaint or enforcement action recorded against the licensed premises or the licensees for at least 2 consecutive years before blah blah blah. Or does not receive any objection or adverse comment from the public from its license renewal application advertisement, or B, the licensed premises have not caused unreasonable nuisance to the persons residing in the vicinity. So with regard to these, if these 2 conditions have been met, then no license for more than a year should be issued. So that's our amendment. So, Bureau Director and the DAB, please give a fair account to your district councillors because you put up posters saying that you're against the renewal of the license for 2 years. But then if our amendments are vetoed, then in fact all the application for renewal will be given a 2-year license. Of course, the Bureau Director said that there would be an interim review by the Bureau, by the board, and then there are certain factors that would be taken into account, but then that's not stated in the law. So what you said just now are just verbal undertakings. Would you be prepared to come up with guidelines, and will the board be following your guidelines? But then if the wording in your guidelines is different from that in the law, then of course you said that the board would have flexibility. But then to what extent will residents' rights and interests be protected? What I find to be heartrending is that when it comes to issues affecting people's livelihood, we should not just because of political bickering veto any suggestion that has been made. So how are we able to be accountable to the residents in the Central and Western District and also Prince Edward District? All right, you said that for people or premises that have been subject to substantiated complaints or enforcement actions, they should not be granted a license for more than a year. In fact, if you look at the resolution in the Central and Western District Council, I don't know if you've been shown the wording. What you said just now was not what I stated in the paper. Well, how can you say that the license will be granted for 3 years or 30 years? In fact, immediately before the renewal of license, unless the board is satisfied that the 2 conditions are met, it should not be issuing any license with a validity period for more than a year. So how can it be 3 years, given the wording here? I find it regrettable, and I hope that you can explain to the Central Western District residents. Thank you.
各位提出嘅待決議題係善眾加議。
I now propose the question to you, and that is that the motion moved by Mr. Sin Chung-kai be passed. Will those in favour please raise their hands? Ms. Helena Wong, I claim a division. All right, the bell will ring for 5 minutes.
開始表決。
Voting begins.
請改核對表決。
Please check your votes. If there is no question, voting is closed and the results will be displayed. Those returned from the FC, 26 present, 6 for, 19 against, 1 abstention. Those from the GC, 22 present, 11 for, 10 against, no abstention. The question is not agreed by majority respectively of each of the two groups of members present. I declare the motion negatived.
梁君彥議員根據
Mr. Andrew Leung